Learning outcomes. After studying this module, you shall be able to know that about the various sections of Indian Penal Code 1860 related with toxicology, various sections of Code of Criminal Procedure 1973 related with toxicology, and learn about the various acts like Pharmacy Act, Drug Control Act, Drug and Magic Remedies Act. Now students, let us start with the introduction of this module. According to the National Crime Records Bureau (NCRB) and Ministry of Home Affairs annual report, death due to poisoning reported in the year 2014 was 20,587, and the percentage was somewhat around 4.6% of the total reported accidental death, which is fortunately much less than the previous year's figures. Even though poisoning cases constantly leads to a cause of worry for the government. As we know that forensic toxicology deals with the medico-legal aspects of the harmful effects of chemicals on human beings, the term legal abundantly clarifies the conspicuous incursion of law into the field of toxicology. A number of legal statutes have been passed which are constantly being regulated and controlled so as to control the manufacture, sale, distribution and possession of poisons and drugs. The advent of poison is an ancient as the human civilization is, and the first ever law related to poisonous substances seems to be from Lex Cornelia circa of 82 BC, which later named out to be a regulatory statute focused at the careless dispensage of drugs. In India, some of the major statutes related to poisonous substances and their handling or mishandling essentially exist, which have been discussed in this module. Now students, let us start with the Indian Penal Code of 1860. The following sections of Indian Penal Code deals directly or indirectly with offences involving poison. Section 272, adulteration of food or drink intended for sale. It states, whoever adulterates any article of food or drink so as to make such article noxious as food or drink, intending to sell such article as food or drink, or knowing it to be likely that the same will be sold as food or drink, shall be punished with an imprisonment of either description for a term which may extend to 6 months, or with the fine which may extend to 1,000 rupees, or with both. Food adulteration is a menace in the present day criminalities. To gain more pecuniary benefits, chemicals are used in the edible material for various purposes which include artificial taste, early ripening among others. Most of these chemicals are even hazardous in nature. Next is section 273, sale of noxious food or drink. Whoever sells or offers or exposes for sale as food or drink any article which has been rendered or has become noxious or is in a state unfit for food or drink, knowing or having reason to believe that the same is noxious as food or drink, shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine which may extend to 1,000 rupees, or with both. According to Merriam-Webster Dictionary, the term noxious means physically harmful, that is, any substance which may produce the harmful effects. Section 274, adulteration of drugs. Under this section, it states that whoever adulterates any drug or medical preparation in such a manner as to lessen the efficacy or change the operation of such drug or medical preparation, or to make it noxious, intending that it shall be sold or used for, or knowing it to be likely that it will be sold or used for any medical purpose, as if it had not undergone such adulteration, shall be punished with an imprisonment of either description for a term which may extend to 6 months, or with fine which may extend to 1000 rupees, or with both. Next is section 275, sale of adulterated drugs. Under this section, whoever knowing any drug or medical preparation to have been adulterated in such a manner so as to lessen its efficacy, to change its operation, or to render it noxious, sells the same, or offers or exposes it for sale, or issues it from any dispensary for medicinal purposes as unadulterated, or causes it to be used for medicinal purposes by any person not knowing of the adulteration, shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine which may extend to 1000 rupees, or with both. Next is section 276, sale of drug as a different drug or preparation. Whoever knowingly sells or offers or exposes for sale or issues from a dispensary for medicinal purposes any drug or medicinal preparation as a different drug or medical preparation shall be punished with imprisonment of either description for a term which may extend to 6 months, or with a fine which may extend to 1000 rupees, or with both. Next is section 277, fouling water of public spring or reservoir. Under this section, whoever voluntarily corrupts or fouls the water of any public spring or reservoir so as to render it less fit for the purpose for which it is ordinarily used shall be punished with an imprisonment of either description for a term which may extend to 3 months, or with fine which may extend to 500 rupees, or both. Next is section 278, making atmosphere noxious to health. Whoever voluntarily vitiates the atmosphere in any place so as to make it noxious to health of a person in general dwelling or carrying on business in the neighborhood or passing along a public way shall be punished with fine which may extend to 500 rupees. Next is section 284, negligent conduct with respect to poisonous substance. This section deals with the negligent conduct in relation to poisons, and it states whoever does with any poisonous substance any act in any manner so rash or negligent as to endanger human life or to be likely to cause hurt or injury to any person, or knowingly or negligently omits to take such order with any poisonous substance in his possession as is sufficient to guard against any probable danger to human life from such poisonous substance shall be punished with imprisonment up to 6 months or fine up to rupees 1000 or both. The crux of this offence is culpable negligence with regard to the poisonous substances. The fact that a person has the custody of any dangerous substance suffices itself to impose upon him the duty of being careful. Next is section 299 pertaining to culpable homicide. This section deals with culpable homicide. It states whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, or with knowledge that he is likely by such act to cause death, commits the offence of culpable homicide. Such acts comprise the use of poisonous substances apart from the conventional weapons of assault. Next section under IPC 1860 is section 300 pertaining to murder. The concern of murder is dispensed within this section, which is analogous to the definition of culpable homicide under section 299 of IPC, but it puts more emphasis on deliberate intention and premeditation. The punishment for culpable homicide can be any term of imprisonment up to a maximum of life sentence, but that for murder can extend to the imposition of death penalty, the minimum sentence being the life imprisonment. However, the detection of intention in poisoning cases are among the most difficult to distinguish and bring to justice. Next section is section 304A, causing death by negligence. It deals with death caused by a rash or negligent act and states whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with an imprisonment up to 2 years or fine or both. Such act of negligence can be with reference to the handling or storage of poisonous substances apart from carelessness in the use of a vehicle or machinery. For example, if a chemist leaves the storeroom containing toxic drugs unlocked and accidentally a child consumes those drugs out of his curiosity, leading to his death. In that circumstance, the chemist will be held guilty under this particular section. Besides section 304A, such cases may also attract section 284 of IPC. Next is section 324, voluntarily causing hurt by dangerous weapons or means. This section deals with the causing of hurt by any dangerous weapon or means, including the use of a poisonous substance. It states whoever voluntarily causes hurt by means of any instrument for shooting, stabbing or cutting, or any instrument which when used as a weapon of offense is likely to cause death, or by means of fire or any heated substance, or by means of any poison or any corrosive substance, or by means of any substance which is deleterious to the human body to inhale, to swallow, or to receive into the blood, or by means of any animal, shall be punished with an imprisonment up to 3 years or fine or both. Next is section 326, voluntarily causing grievous hurt by dangerous weapons or means. Under this section, whoever, except in the case provided for by section 335, voluntarily causes grievous hurt by means of any instrument for shooting, stabbing or cutting, or any instrument which used as a weapon of offense is likely to cause death, or by means of fire or any heated substance, or by means of any poison or any corrosive substance, or by means of any explosive substance, or by means of any substance which is deleterious to the human body to inhale, to swallow, or to receive into the blood, or by means of any animal, shall be punished with an imprisonment for life, or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. The wording of this section is very similar to that of section 324, except for the fact that the injury caused should be of any of the 8 types as has been mentioned under section 320, namely emasculation, permanent privation of sight, hearing, any member or joint, the impairment of the power of any member or joint, permanent disfiguration of head or face, fracture or dislocation of any bone or tooth, any hurt which endangers life or causes the sufferer to be in severe bodily pain or unable to follow his ordinary pursuits for a minimum period of 20 days. Next is section 328, causing hurt by means of poison etc. with an intent to commit an offence. Like section 284, this section also deals specifically with poisons. It states, whoever administers to any person any poison or any stupefying, intoxicating or unwholesome drug with an intent to cause hurt to such person shall be punished with imprisonment up to 10 years and shall also be liable to fine. Now students will study about the Code of Criminal Procedure or CRPC 1973. The Code of Criminal Procedure, being a procedural law, deals with the judicial proceedings at various stages of inquiry and trial. Starting with, first we have section 39, that is public to give information to certain offences. Chapter 4b of the CRPC talks about aid to the magistrates and the police. Section 39 under this chapter says that all cases of homicidal poisoning, whether definite or suspected, must be compulsorily reported to the police as per section 39 subsection 1 of the Criminal Procedure Code. Failure to do so will make him culpable under section 176 of the Indian Penal Code or IPC. Subsection 1 summarily states, as every person aware of the commission of or of the intention of any person to commit any offence punishable under any of the following sections of the Indian Penal Code, that is 45 of 1860, namely sections 272 to 278, both inclusive, that is to say offences relating to adulteration of food and drugs, etc. Section 302, 303 and 304, that is to say offences affecting life. Next is section 174, police to inquire and report on suicide, etc. It says, when the officer in charge of a police station or some other police officer, especially empowered by the state government in that behalf, receives information that a person has committed suicide or has been killed by another or by an animal or by machinery or by an accident or has died under circumstances raising a reasonable suspicion that some other person has committed an offence, he shall immediately give intimation thereof to the nearest executive magistrate empowered to hold inquest, and unless otherwise directed by any rule prescribed by the state government or by any general or special order of the district or sub-divisional magistrate, shall proceed to the place where the body of such deceased person is, and there, in the presence of two or more respectable inhabitants of the neighbourhood, shall make an investigation and draw up a report of the apparent cause of death, describing such wounds, fractures, bruises or other marks of injury as may be found on the body, and stating in that manner or by what weapon or instrument, if any, such marks appear to have been inflicted. The report shall be signed by such police officer and other persons or by so many of them as concur therein, and shall be forthwith forwarded to the district magistrate or the sub-divisional magistrate. Third, when the case involves suicide by a woman within 7 years of her marriage, or the case relates to the death of a woman within 7 years of her marriage in any circumstances raising a reasonable suspicion that some other person committed an offence in relation to such women, or the case relates to the death of a woman within 7 years of her marriage and any relative of the woman who has made a request in this behalf, or there is any doubt regarding the cause of death, or the police officer for any other reason considers it expedient so to do, he shall, subject to such rules as the state government may prescribe in this behalf, forward the body with a view to its being examined to the nearest civil surgeon or other qualified medical man appointed in this behalf by the state government, if the state of the weather and the distance admit of its being so forwarded without risk of such putrefaction on the road as would render such examination useless. The following magistrates are empowered to hold inquest, namely any district magistrate or subdivisional magistrate and any other executive magistrate specially empowered in this behalf by the state government or the district magistrate. Next section is section 176, inquiry by a magistrate into cause of death. When any person dies while in the custody of police or when the case is of the nature referred to as in clause 1 or clause 2 of subsection 1, I repeat of subsection 3 of section 174, the nearest magistrate empowered to hold inquest shall, and in any other case mentioned in subsection 1 of section 174, any magistrate so empowered may hold an inquiry into the cause of death either instead of or in addition to the investigation held by the police officer, and if he does so, he shall have all the powers in conducting it which he would have in holding an inquiry into an offence. The magistrate holding such an inquiry shall record the evidence taken by him in connection therewith in any manner hereinafter prescribed according to the circumstances of the case. Whenever such magistrate considers it expedient to make an examination of the dead body of any person who has been already interred in order to discover the cause of his death, the magistrate may cause the body to be discerned and examined. Where an inquiry is to be held under this section, the magistrate shall, whoever practicable, inform the relatives of the deceased whose names and addresses are known and shall allow them to remain present at the inquiry. Next, students, we will study about the Poison Act of 1990. This act was amended in 1958 and repealed in 1960. It deals with the import of poisonous substances into India, issuance of license for possession of certain specified poisons, and restriction in the sale of such substances, mostly chemicals, as poisons, over which control is to be exercised. Next, we will study about the Drugs and Cosmetics Act of 1940. This act was amended in 1964 and very recently in 2008 and is today referred to as the Drugs and Cosmetics Amendment Act of 2008. It deals with the import, manufacture, distribution and sale of all kinds of drugs like allopathic, Ayurvedic, Unani, Siddha, etc. besides cosmetics. As per the Act, every patented or proprietary medicinal preparation should display on the label of the container either the exact formula or the list of the ingredients. The amended Act has enhanced the scale of punishment for various offences including the sale of spurious drugs, adulteration of drugs and cosmetics, toxic contamination, etc. Next is Drugs and Cosmetics Rules of 1945. This is a branch of the Drugs and Cosmetics Act of 1940 and is concerned largely with the standard and quality of drugs apart from exercising control over the manufacture, sale and distribution of drugs and cosmetics. It was amended in 1988 and is now referred to as the Drugs and Cosmetics Rules 8th Amendment of 1988. All categories of drugs used in therapeutics have been comprised: allopathic, homeopathic, Ayurvedic, Unani and Siddha. All drugs and cosmetics are compulsory to be categorized and packed properly. To advise the central and state governments on technical matters relating to drug control, the following boards have been set up: the Drugs Technical Advisory Board, the Ayurvedic and Unani Technical Advisory Boards, the Drugs Consultative Committee. In order to expedite the analysis or testing of the drug samples to assess their quality, the Central Drugs Testing Laboratory or CDTL was established in the year 1962. Individual states have also set up the drug control laboratories. Rigorous punishments have been laid down for manufacture, stocking or sale of inferior or spurious drugs. Next is the Pharmacy Act of 1948. The objective of this statute is to allow only registered pharmacists to compound, prepare, mix or dispense any medicine on the prescription of a registered medical practitioner. Under this Act, the Pharmacy Council of India, New Delhi has been established under the Ministry of Health and Family Welfare, which regulates the study of pharmacy throughout the country. Individual states have their own state pharmacy councils for the registration of pharmacists. Next is the Drug Control Act of 1950. This act controls the supply and distribution of drugs and also guides the manufacturer or dealer in fixing the maximum price for every drug. Next, we will study about the Drug and Magic Remedies Objectionable Advertisement Act of 1954. The purpose of this act is to make sure that ethical standards are retained when drugs are promoted by the manufacturers. Advertisement which cause offense, decency or morality can be barred under this act. All those which claim magical powers for certain drugs, example enhancement of potency, cure for incurable diseases, etc. Magical remedies include the use of talismans or charms such as mantras, kavach, etc. Next is the Medicinal and Toilet Preparation Excise Duty Act and Rules of 1955. This enactment deals with the regulatory problems arising out of the usage of alcohol in medicinal and toilet preparations. It has helped greatly in reducing the large-scale interstate trafficking of alcoholic, medicinal and toilet preparations which existed before due to different rates of excise duties in different states. This act has made uniform rates of duty applicable throughout the country. Next, we will study about the Narcotic Drugs and Psychotropic Substances Act of 1985. The Narcotic Drugs and Psychotropic Substances Act or the NDPS Act of 1985 was enacted in India and subsequently amended in 1988 to implement the provisions of the Convention on Psychotropic Substances of 1971 and the Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances of 1988, both held in Vienna. This act renders the three previous acts which are now obsolete, and they are the Opium Act of 1857, the Opium Act of 1878 and the Dangerous Drugs Act of 1930. The term narcotic in the legal sense is quite different from that used in the medical context, which denotes a sleep-inducing agent. Legally, a narcotic drug could be an opioid, which is a true narcotic, or cannabis, which is a non-narcotic, or even cocaine, which is the very antithesis of a narcotic, since it acts as an stimulant. The term psychotropic substances is with reference to a mind-altering drug such as LSD, phencyclidine, amphetamine, barbiturates, methaqualone, benzodiazepines, mescaline, psilocybin, and the designer drugs such as MDMA, DMT, etc. The NDPS Act enforces complete prohibition on the cultivation of coca, poppy, and cannabis plants, and the manufacture, sale, purchase, use, or transport of any narcotic drug or psychotropic substance except for medical or scientific purposes. The minimum punishment for any offence committed under this Act is 10 years rigorous imprisonment and a fine of rupees 1 lakh, while the maximum punishment is 20 years of rigorous imprisonment and a fine of rupees 2 lakhs. There is also sufficient scope under the NDPS Act for enhanced punishment for recurrence of offences, specifically after the previous convictions, which includes the imposition of even death penalty. To constitute an offence, the first time around the minimum quantity seized should be equal to or over 250 milligrams for heroin, 5 grams for hashish or charas, 5 grams for opium, 125 milligram for cocaine, and 500 grams for ganja. In addition to persons directly involved in trafficking narcotic drugs and psychotropic substances, any person who finances trafficking or harbors a person involved in trafficking or abets or is a party to a criminal conspiracy, including a criminal conspiracy to commit an offence outside India, is also liable to the same scale of punishments. However, immunity from prosecution is given to addicts volunteering for detoxification. Section 64A of the NDPS Act states that any addict who is not charged with any offence punishable under Section 15 to 25 or Section 27A and who voluntarily seeks to undergo the medical treatment for detoxification or de-addiction from a hospital or an institution maintained or recognized by the government or a local authority and undergoes such treatment shall not be liable to prosecution under Section 27 of the Act once in his lifetime. Such immunity granted may be withdrawn if the addict does not undergo the complete treatment, and in such circumstances the accused shall be prosecuted for the said offence. Further, the Act makes a distinction between a possession for personal consumption and trafficking. The punishment for the former being limited to between 6 months and 1 year only. The Central Government of India established Narcotics Control Bureau (NCB) in 1986 under the Ministry of Home Affairs with its headquarters at New Delhi and zonal offices at Mumbai, Kolkata, Chennai and Varanasi. In the year 1988, the central government instituted the Narcotic Drugs and Psychotropic Substances Consultative Committee, consisting of a chairman, the Minister of Finance or the Minister of State in the Ministry of Finance, and 18 members from diverse fields who would, among other functions, conduct periodic review of the NDPS Act. Next, here we have shown a table wherein on one column we have the narcotic drug or the psychotropic substances and the quantities in kg. For opium it is 10 kg, for morphine it is 1 kg, heroin 1 kg, for codeine it is 1 kg, for thibine it is 1 kg, for cocaine it is 0.5 kg, for hashish it is 20 kgs. Any mixture of the drugs that I have already said is 1.5 kgs. LSD or lysergic acid dithylamide 0.5 kgs. THC or tetrahydrocannabinol 0.5 kgs. amphetamines 1.5 kgs, methaqualone 1.5 kgs, salts and preparation of the already said substances or the psychotropic drugs or narcotics will be 1.5 kgs. So in this table we have shown the minimum quantity of seizure in repeated offense for imposition of death penalty. Next, students, we will study about the medico-legal complications involving consent. The consent of a patient is essential for all diagnostic and therapeutic procedures, mainly those which are invasive or risky in nature. Undertaking such procedures without consent can amount to an assault in the legal sense, even if it is done for the benefit of the patient unless explanatory situations exist. A patient who has knowingly consumed a poisonous substance or overdosed a therapeutic drug is likely to be persistent and may repel all effects at treating him. The attending physician may then be uncertain as to the legal implications of forcing treatment on the patient, who may even threaten the doctor with a lawsuit if therapeutic procedures are forcefully carried out. It is, however, a fact that a patient who attempts suicide has lost the right to refuse treatment, and no court has so far upheld a patient's complaint of forced treatment in such circumstances. It is also true that in many such cases of toxic ingestions, the patient can be declared unreasonable enough to refuse treatment on account of depression or disturbance of mental functions which can be believed to impair the judgment. On the other hand, a physician may become liable for negligence if he does not do what is medically indicated. There are times, however, such as in an excitedly distressed or extremely stubborn patient, when over-enthusiastic attempts to remove a poison or drug overdose may place the patient at greater risk of physical harm than the injection itself. In the case of a comatose patient, consent must be obtained from the next of the families. However, if it is an emergency and consent is being refused on the unreasonable grounds, the medical doctor can go ahead with the compulsory treatment even in the absence of consent. In such cases, the court will always support his decision if it comes to a legal action, since it was made in good faith with the safety of the patient as the major consideration. It is appropriate to note that if an accused person has been arrested and then brought for examination, where it can be rationally believed that such examination can afford valuable evidence as to the commission of an offence, it is not necessary for consent to be obtained from the individual. Medical examination can be carried out in such cases on the basis of a request made by a police officer not below the rank of a sub-inspector. Now, students, let us summarize this module. Forensic toxicology deals with medico-legal aspects of the harmful effects of chemicals on human beings. A number of legal statutes have been passed which are constantly being regulated and controlled, and they are controlling the manufacture, sale, distribution and possession of poisons and drugs. The term narcotic in the legal sense is quite different from that has been used in the medical context, which denotes a sleep-inducing agent. The NDPS Act enforces complete prohibition on the cultivation of coca, poppy and cannabis plants and the manufacture, sale, purchase, use or transport of any narcotic drug or psychotropic substance except for medical or scientific purposes. A patient who has knowingly consumed a poisonous substance or overdosed a therapeutic drug is likely to be persistent and may expel all efforts at treating him. Thank you.